In Alberta, to prove bad faith termination in an Alberta courtroom, an employee must demonstrate they suffered serious and prolonged mental distress as a direct result of the manner of their dismissal. Alberta courts have clarified since the landmark Sadati v. Moorhead and Lau v. RBC decisions that a formal medical diagnosis is not strictly required to win these damages, though it remains highly beneficial. Because a formal diagnosis isn't mandatory, courts frequently rely on the testimony of people who observed the employee before and after the termination, like family and friends, who were witnesses who can describe tangible changes in behavior, such as social withdrawal, loss of appetite, irritability, or constant lethargy. Former colleagues or coworkers who witnessed the actual dismissal or the employer's conduct leading up to it and can corroborate claims of humiliation or unfairness. And personal testimony, the employee's own account of their distress. However, Alberta courts warn that this self report is often insufficient on its own if it isn't backed up by third party evidence. Concrete records help prove the employer's conduct and the employee's subsequent decline. Communications like emails, text messages, or logs showing the employer was misleading, untruthful, or playing hardball during the firing. Internal records are performance reviews that were suddenly negative without cause, or HR complaints that were ignored. Employment searches include evidence showing that the employer's bad faith conduct, like refusing a reference or sabotaging their reputation, directly hindered the employee's ability to find new work. While not a barrier to a claim, medical evidence is still considered the best or most persuasive form of proof, like doctor's notes, which contain records of visits to a GP or therapist specifically discussing the distress caused by the termination. The prescription history is evidence of new or increased medications for anxiety, depression, or insomnia triggered by the dismissal. The physical symptoms are documentation of physical manifestations of stress, such as significant weight loss, hair loss, or stress induced illness. The most critical part of the evidence is proving that the distress was caused by the employer's bad conduct, not just the normal upset of losing a job. Evidence must show in a timeline that the severe symptoms began or significantly worsened immediately following the specific bad faith acts. Example, a public firing or false accusation. In a holistic context, courts look at factors like the employee's age and length of service to determine if the employer's conduct was reprehensible or egregious in that specific context. Thank you for listening to these essential steps in contemplation of filing your wrongful dismissal claims. We hope that you've gained insight and information, or if you have questions, write to us at Courts of Justice Agency at outlook.com, and let's discuss how we can help you start your claim today.